Good morning, everyone. Good morning. Thanks for joining us here today on behalf of Attorney General Maura Healey and my colleague Jocelyn Jones, who's the Deputy Chief of the Fair Labor Division. I want to welcome you. My name is...
Fleming, please come to the Circulation Supervisor's office. Peter Fleming to the Circulation Supervisor. Thank you.
That was part of the formal program, so yes, plan. My name is Jonathan Miller. I'm Chief of the Public Protection and Advocacy Bureau in the Attorney General's Office. And thank you all for joining us here this morning to listen and participate in this hearing on the earned sick time law and the draft regulations that have been promulgated by the Attorney General's Office and that are set to be finalized in the next couple of weeks. So Jocelyn's going to go over some of the ground rules for the hearing today, but we really appreciate your making time to be here with us today. We look forward to your comments and your questions and to continuing the conversation that's been ongoing throughout the Commonwealth over the last few months about this law. Thank you.
Okay. Good morning. So with respect to those who would like to testify, we're going to be calling names, and if you could kindly limit your testimony to 3 minutes. If you have come with written testimony and would like to leave it for the record, please leave it on the desk as you exit. If you came and were not planning to testify but become inspired to do so, please feel free to submit testimony. We have a website. There's a piece of paper that has the website address, and I think it's earned Sicktime at state.ma.us. And you can feel free to send comments in up and until June 10th. And I believe that's the close of the regulation public comment period. Let me think. What more do I need to let people know? There are, for those of you who haven't seen already, our website has an abundance of information, materials, facts, fact sheets with regards to the earned sick time law, which we will be continually updating over the course of time to ensure that employers and employees understand their rights and responsibilities under the law. And we also have a lot of materials for you to take with you as you leave today if you're interested in doing so. This is a public hearing, an official public hearing, so the testimony that you may give will be recorded for public records purposes. And I think with that, we're ready to start.
So I believe Julie Sloan is first on our list.
No, actually, I just had a question that I'm sure will come up.
Okay.
I also wanted to let folks know that following the hearing, we'll stick around to answer questions that people might have following the hearing. Thank you.
Daniel Margolis. You can come right up here, please. Thank you. I think we can leave it right here. Pick us up. What's that? I think if we leave this right here.
Thank you for your time today.
Good morning.
Good morning. The question I have, one of the challenges for employers is the tracking of the time of this new law, where they may not have payroll systems in place, and it is an expense to go out and purchase tracking the time of their employees moving forward. So if an employer is interested in making sure that the employees do adhere to the law, get the owed time that they're entitled to at the beginning of each calendar year or whatever fiscal year, would the state allow that to be given to the employees at the beginning of the year if in good faith they're going to give them the time without tracking it, and if they do ask for the time, they'll get it? And the reason I ask, in California, where there's a similar law, there is a provision that if you state a policy that you give the time at the beginning of the year, you don't need to track the time.
And when you say track the time, do you mean the accumulation?
The accumulation
of
for every 30 hours worked.
Okay, yeah. Providing a lump sum at the beginning of a period or periodically is a permissible way to administer the law without having to track the accrual of hours.
Okay, so they wouldn't need to show on a payroll system like to have the time tracked from what you're saying.
Right. You don't have to track 1 hour for every 30 if you're giving a lump sum up front.
Okay.
You'd probably, be advised to keep track of what time is used so that if there's ever a dispute as to if an employee's used more than the time that had been provided or less, whatever, that you have documentation of that.
Okay, great. All
Okay.
right. All right. Thank you very much for your
Okay.
time.
Thanks for coming.
Thank you.
I think it's Nancy White.
Morning.
Morning. I actually have a couple of questions. We have a collective bargaining agreement, and I have all kinds of rules already worked out in the collective bargaining agreement that may not fit with this law, and I'm just trying to figure out how we're going to make all this work.
If you, for those of you who aren't aware, the Attorney General issued a regulation that provides a safe harbor for employers that are already doing the right thing by providing sick time to employees, as long as they're entitled to get 30 hours during the course of the 2015 year. So to the extent that you might have a policy that already provides for sick time, and does the collective bargaining agreement provide for sick time?
It's a paid time off bank, essentially.
Okay. So if you have a paid time off bank or other time that can be used for sick time, whether it's vacation time or PTO time or personal time, that is sufficient to sort of satisfy the provision of time. You have until January 1st, 2016 to get all of your policies in order to comply in full with the requirements of the law.
Okay, so some of the finer points of some of those policies, I guess, I'm still in question on. And one of them in particular is FMLA.
Mm-hmm.
So currently, in the contract, it says if you take FMLA for yourself, you don't have to take vacation time or PTO time. But if you use FMLA for a family member, you do have to use it. But I think in the law, it says the employee does not have to use paid sick time. So am I going to be,
Do you mean in the earned sick time law?
yes.
Okay. Well, there is one clarification that we will be making to the regulations as concerns its interaction with the earned sick time law's interaction with other leave laws like FMLA, and that is that to the extent that your both the use for under earned sick time and FMLA are consistent, they run concurrently, not, and so you can use your earned sick time under FMLA. There's some,
But the contract says that if you're using it for a family member, you have to use earned sick time or PTO or vacation time. So, and I think in this new law, it says that the employee doesn't have to use it if they don't want to. So am I in conflict with the law by telling them they have to use it if they're using it for a family member?
you can require someone to use to stay on the payroll, and if the only way that they can stay on the payroll is by using their time, then that's permissible, by being required to use the time that their earned sick time.
I don't think that being on the payroll comes into it.
Well, if you're not going to be paid, if you're not getting paid, you're technically off payroll.
Well, this is a union too, so, that's not, I can't take somebody off the payroll.
I'm saying that employers can require an employee to use paid time
Okay.
to cover absences. They don't have, there's no individual right to take, to be off the payroll. So
Okay.
if staying on the payroll and not getting paid, using the earned sick time is, if that's consistent with the use of time, then you can require that.
Okay. And the other piece was, this is supposedly the smallest increment that your payroll system can handle. which in our payroll system, it's a decimal point
Right.
of an hour.
We're going to be making some clarifications around our interpretation of that, so you can look for that in the final regulations.
Okay, so, our concern is, like, if somebody's comes in 15 minutes late, and they're just going to come in and say, I didn't feel good, so I want to use 15 minutes of paid sick time.
Right.
In the meantime, I have a whole crew standing around waiting to go to work because this guy didn't show up, so
Right.
there's got to, we
You
need
will
to
be
work
seeing,
on...
we'll be working,
Okay.
we are revising the
Well,
regulations
and
to
there-
give some greater clarity to that
And there are a
point.
number of provisions within the regulations that protect against abuse and misuse by employees that afford protections to employers who are concerned that earned sick time is being used inappropriately.
Okay.
So that's something else that you can.
Is that going to be clarified a little bit more?
I mean, that's
Because
in
I'm-
the regulations already.
Yeah, I see that, but it's like, they're going to say I didn't feel good. So I'm not sure how I can argue with that. I can't ask for documentation of any kind, so.
Right, but you can ask them to verify that they used it for permissible purposes allowed under the law.
Yeah, so sign something and
Yeah,
then keep a record of it.
yes.
Okay. Okay, thank you.
Thank you.
Thank you. Okay. Go ahead, next person.
Greg McDonald. Good morning.
Good morning, thanks for letting me speak today. My name is Greg McDonald, and I'm an owner of the Common Market Restaurant. And I came from Boston today because I believe this issue is one of the most important I've seen in a long time as a small business owner. Historically, even though we like to criticize and even tease the legislature, the process of negotiation and listening and trying to find the right fit for a bill has worked better than ballot questions, which often appeal to the emotions of the public and haven't been thought all the way through, and they're often filled with unanticipated problems, and I think this bill has some of them in there. Small business owners are worried. They have Obamacare coming at them, years of minimum wage increases, and now sick leave, and that's a tough 1, 2, 3 punch. My family business is restaurants, and I employ approximately 75 teenagers. I completely understand offering some sick time to adults of a certain age who work a certain amount of hours per week, say over 21 years old and 30 hours per week. This will especially help many struggling people and allow for a safer, healthier workplace. But the bill as it stands now can have a teenager call in, quote, sick, with short notice, and go to a party or a concert and get paid to do it. This will happen. If you worked with teenagers like I do, you know this will happen. My own 16-year-old daughter laughed when she told me, Dad, I work for you 7 hours a week. It's 1 shift a week. And you owe me 12 sick hours next year. So the way I will react to this mandated cost is I'll need to eliminate, I estimate, 20 positions and raise my prices. I simply have no other cards in the deck. I'm on the board of a 600-member independent restaurant buying group, and I'm also on the board of my local Chamber of Commerce. And from listening to other owners of all types of businesses, I can tell you with certainty that business owners will be much more reluctant to hire teenagers. Many have told me they plan to lay some off because of this proposed law. They would rather have one worker work 45 hours a week than have 3 part-timers work 15 hours each. And teenagers are often those part-timers. It was the talk of our meeting this week. If you're listening, you know the teenagers, especially city kids, are having a hard time finding seasonal jobs, as can be referenced in this recent Boston Globe article, just came out last week. Mayors, parents, youth counselors all love when teenagers work. This law will make it much more difficult. I worry because when I listened to your earlier testimony, which I listened on the recording, Attorney General Maura Healey says herself that this is, quote, not the first paid sick leave law in the country, but it will be the most expansive, and that's okay. It's a good thing, quote. I can't imagine when teenage employment drops, like it will, she wants that to be part of her legacy. The way I see options from here, 2 suggestions. The first is, I would say, due to the confusion that exists currently, to delay this until January 1st. Final regulations don't even finish until the 10th, and they need to be communicated to owners who need to communicate that and adapt that to their own policies and communicate that to their staff. That's in 20 days. And don't forget, this is a suable matter. And Attorney General Healy claims she wants, quote, clarity at the end of the day. I simply do not see it in 20 days. I respect this listening tour and hearing process. I welcome it, and I'm glad that you guys put it together, and I welcome it. The second suggestion is I would hope that you would consider amending the areas such as age and minimum hours worked, especially to address the real concern of teenage jobs and the real threat that this bill is to them. Thank you for your time.
Thank you very much.
Danielle Tenizar.
Good morning. My name is Danielle Tenzar. I'm here from Whole Foods Market. This is my second hearing to hopefully finish answering questions so I can implement the policy properly. So when are the final regulations supposed to be issued?
They will be up on our website on June 19th.
Okay. All right. So that's good. So we'll have at least 2 weeks to be able to train everyone. So my first question is, with regard to, I think it's section 3303 for the transition year, with regard to accrual and use. What if an employee has already used sick time during this year? Is there credit for that? So if someone's already used 20 hours, so how much are we obligated to still provide? If someone's already used 20 hours this year, how much are we still have to provide for the remainder of the year?
If they've earned if they have earned 40, then they can take the remainder 20
Okay.
hours.
All right.
Unless your policy provides for more.
Okay, because we do. I mean, we have a PTO policy, and it provides for 86 hours in a year.
But you do for for purposes of this year, earned sick time that has been used already can be counted towards what would be an employee would be entitled to during the course of the year.
Okay. And then with regard to that same section, number 14, it does reference employers will, an employer shall not be required to provide more than 40 hours of earned paid sick time during the transition year. Any paid leave given prior to July 1st, 2015 will be credited. So again, we have a PTO policy. We don't care what people use it for. If someone's gone on vacation and they've already used 40 hours, are we considered, is that fulfilled at this point? As long as we can show that the person's taken the time. Okay. And then my last question was, is the 40 hours prorated at all for someone who's part-time or seasonal for the remainder of the year?
No, I mean the law has that requirement that accrual is 1 hour for every 30, regardless of how many hours one works.
So even though someone who's part-time, who under the new accrual method, say they work 20 hours next year, they would only accrue 16 hours for next year. They're still going to be able to use up to 40 hours for the remainder of this year, if they're part-time.
I'm sorry, I didn't follow you. They don't get to use any more than they earn, and they can't earn more than 40. They can't accrue more than 40.
So we're part of the safe harbor, though. We're sticking with our same accrual for the remainder of this year. Mm-hmm. So if someone works part-time, they can still use up to 40 hours, like if they have it, because we let people just continually carry over their PTO every year.
However, the law doesn't discriminate between part-time and full-time employees in terms of what they use and what they can use.
Okay, so if I have a part-timer or someone who's seasonal for the remainder of this year, if they have 100 hours of PTO built up, I still have to let them use 40 hours.
Yes. They should be treated like full-time
Okay.
employees in terms of their rights.
Okay, so there's no prorating. Okay. And then the last thing I just wanted to just kind of comment on is Section 3306, the documentation. So I understand if someone has to be out, they have to use 24 hours of consecutive time.
That's statutory.
Right. And then after that, the employer can ask for verification. And if someone doesn't have a health care provider, they can simply just sign a note saying I was sick.
Do you have a question? I'm sorry.
So so if someone is out for 3 days or 4 days, and then the employer at that point asks to verify, and the person says, I don't have a health care provider, they can just sign a note saying they were sick.
We will be adding some additional information about what it means to not have a health care provider in the final version of the
Okay, because I just urge you, that is just like ludicrous. Any other unpaid leave, any leaves of absence, required by federal and state law, there's some sort of verification. And for someone to just sign saying, oh, I was sick, or I was 15 minutes late because I had to go to the bathroom, or my child was sick. Why even bother having a verification process if it's just going to be simply that you can sign an affidavit? If you look at other states that have similar laws, there's an actual genuine certification process for that.
In what way? For
certification from a healthcare provider.
Right. And the statute in this case contemplates that someone might not have one, so that's what we're trying to fill in here. There's no requirement that you have a healthcare provider.
Yeah.
And the statute explicitly provides that we come up with a system for people who don't have a health care provider. And right now the affidavit is what we have contemplated. We will be adding further information about what it means to not have a health care provider.
Okay, so maybe, I don't know, maybe there could be some sort of provision too, like if you're on the company insurance and we know you have insurance, you should certainly have a health care provider. It's just kind of like we have Obamacare in Massachusetts, health insurance is required. So most people this day and age probably have a health care provider. So again, just something to think about, just because from an administration standpoint, that is a lot.
Well, and just to clarify again, that's after 24 consecutive
Correct.
hours. Right. Before that, you can request verification that it was used for permissible purposes. Even if it's less than 24 hours of consecutive missed time, right? They miss an hour, you can request them to verify that they used it for permissible purposes.
So again, how are you requesting them to verify that they're just saying that they used it?
They're verifying it for you on a documentation for your company.
Right. It's just I guess what I'm just saying is we've already administered this in Connecticut, and there is the requirement that you have to provide certification. It's it's very easy for someone to just say, my child was sick, I was sick, and and that does happen. Believe me, I have kids, but it's also very easy for someone to just say that when they're just late for work. So it's just, the concern of, and when you get down to it, can be down to the minute. That's a lot of time. And
well, like I said earlier, we are planning to be providing some further clarification about the increments of use, the minimum increments of use, and we are going to be providing additional information about the circumstances in which one might not have a health care provider, so that it's not an open catch-all at all.
Okay, and so that is supposed to be out by June 19th?
Yes.
Okay, just because, and again, from an employer standpoint of, I have probably close to 300 managers that I have to train. We have about 5,000 employees that we have to train, and you're talking the law goes into effect July 1st. And so to be able to plan for that and make sure everybody's properly informed and we administer it properly, you need to do some training. And if the law goes into effect July 1st, we don't have that many weeks left to do that.
Yes. So let me let you and everyone else here know that the real focus of this year is going to be making sure that everybody knows what the rules are and how to comply. If there are problems that arise where people are just getting things wrong, we're going to be helping you to correct them. We're not looking to punish employers for making mistakes along the way. We're going to be there to help correct issues, make sure people understand how things work. And so just keep that as comfort. Know that we will continue to be doing outreach and education to employers and employees. And we understand it's an enormously broad law. We are doing our best to try to make sure that people get what compliance entails, and that will be a continuing effort on our part. So.
That might be something then to add in so employers feel a little bit better. I mean, you're saying this is the Attorney General's office, but here's a law, we're expected to comply. So maybe including that someplace too to put employers at ease, because it really is a lot. Like I said, I've already done this in Connecticut. It was a lot, but the difference was there was 6 to 8 months that the state gave you to prepare for this, and everything was already done. So we're like really behind the game here. So that would be helpful.
Thanks for your comments.
Thank you.
Stephen Lellard or Leelard?
I'm all set, thank you.
Okay, thank you. Lee Campbell. Good morning.
I'm from the law firm Morgan, Brown and Joy in Boston. Closer, okay. And we represent employers in a wide variety of matters, and we've been getting a lot of questions about the safe harbor provision. And I know you mentioned the other day at the Boston Bar Association that you're going to be doing an additional publication to explain this a bit more. But we've had a lot of concerns regarding extending 30 hours to employees who are just now going to be rolled into the current system or who are hired later on in the year. And so I was hoping to get some clarification on the record. So a lot of my clients have a system in place where an employee could earn up to 30 hours a year and use it, but it's not necessarily guaranteed. It depends on the number of hours worked. And it's my understanding that that's permissible under the safe harbor provision. Is that correct? Mm-hmm. Okay. And for employees who are rolled into the system, if they're placed on that same accrual rate, it's possible that they won't have the possibility of earning 30 hours because they're not being rolled in until July 1st or later on in the year. And that's permissible as well.
That's right.
Okay. Does it matter if the majority of the employees are part-time and the majority won't be earning 30 hours?
No, as long as they're all covered.
Okay. And for employees or for employers who give a certain set of hours up front, how do you handle employees who are later rolled into the system? Or, for example, if an employer gives 40 hours at the beginning of the year, but now you have an employee who isn't hired until October, you're allowed to prorate that?
So if someone's coming in October with no history with the company?
Correct.
At all. And how is the accrual? How does the accrual work? It doesn't. It's just
it would be front loaded.
Yeah, I would think an accrual would be appropriate in that circumstance.
An accrual, okay. And so it wouldn't be
I mean,
that they
I'm
could
sorry, prorating
a prorated amount
of the months that remain.
And same for part-time.
With respect to the months that remain.
And same for part-time employees who are rolled in. If your current system is full-time employees get a certain number of hours at the beginning of every year, and you're rolling in part-time employees later on in the year, it's possible to give a prorated amount to them as well, even though it would be less than 30 hours.
Based on the time that they have remaining in the year?
Yes.
Yeah.
Okay. That was actually all my questions.
Okay.
Thank you very much.
Rich Gardner. Good morning.
Good morning.
Morning.
Hi, my name is Rich Gardner. I'm a recruiting manager for the Davis Companies, headquartered out of Marlborough, Massachusetts. We operate in the staffing industry, and at any given time have approximately 1,000 contractors who work for us. While we do support the intentions of the paid sick time law, I'm hoping to gain some clarification on a few of the specifics of the rules. The first topic I was hoping to gain clarification on is the accrual of hours outside of Massachusetts and how various regularly occurring scenarios would be handled. The regulations refer to all hours worked by employees outside of Mass if the primary place of business is in Massachusetts, meaning the majority of the hours worked are inside Massachusetts. in a situation where where we would place an employee in, say, New Hampshire for 3 months or any surrounding state, then we were to place them at a client in Massachusetts for just over 3 months, so that the majority of the work would now technically have been done in Massachusetts, would their total hours accruing from the start of the New Hampshire position then need to be retroactively applied at that point?
I hate to say this, but
Sure.
we really need to be taking testimony, and
Sure.
if that's a point that you feel like needs to be clarified, we will. It's
Okay.
We are, as I said, going to be doing question and answers at the end of the hearing.
Okay.
But we're not really set up. We have a lot of people testifying today.
That's fine.
And this is, for instance, a very complicated
It is.
question that is not going to be an instant answer. So
Sure. We
so
were actually more
if you-
concerned
if
about
that's the
potentially losing
question,
accruals.
But your question is like, you need further clarification about out of state work and how that
Yes.
earned sick time applies. And
Yes.
with respect to that, okay, thank you.
We're more concerned actually about the losing accruals potentially for working outside of Massachusetts after the initial period. Second point was really for the restoration of employees after sick time is used. Right now, to my knowledge, there isn't a staffing exception in the rules, which would insulate staffing firms from being liable for the decision-making of their clients. This is a huge concern for us because really the nature of our business is to provide flexibility and business continuity for our clients. And if overall, while we would love to reinstate any employees who do use earned sick time, we realize that that's really beyond our control if a client does choose to end their assignment. As of right now, it looks like the staffing company themselves are pretty highly exposed in the situation.
When you say end an assignment, do you mean because somebody's used earned sick time?
Regardless, if they were to come back from earned sick time in a scenario where potentially they were replaced, or just they found that they could do the work without them, unfortunately, and they weren't reinstated to the same assignment, we didn't have an opportunity to potentially place them at a equivalent position. Then we would be held liable, even if we had educated the client that they really need to reinstate the employee and they choose not to. That would be our biggest concern, was that we wouldn't be able to reinstate them right away, even though that's also something that's very important to us, is to continue to have them work. Okay. Similar to the situation where we really, when we're doing our due diligence with things like OSHA, we're able to go in and make sure that they're in a safe working environment. And this is a situation where if intentions are found to be not good when someone's terminated outside of our control, that's something that we have to deal with kind of after the fact. And we would hope to be somewhat insulated from that risk, at least in some type of a co-employment light where a client would carry some of the responsibility as well. Okay. Lastly, the break-in service rule of 1 year is excessive in our field of staffing, where we're often dealing with seasonal workers, as you guys have heard in the last few locations that we've had testimony. We would hope to propose rules here in line with the ACA, where workers would carry over accruals for more reasonable 6 months, or at least that there might be a 3-month moratorium on using paid sick time for new assignments after 3 months outside of assignment. Okay. This way, our clients wouldn't carry all the burden for an employee's new assignment because of their previous assignment.
Okay.
Thank you.
Thank you.
Thank you.
Thanks for coming.
Georgette Arakelian? I just had a question. Okay, thank you. Robert Branca?
Yes, hi. Thank you for coming. Welcome to Worcester.
Good morning.
Good morning.
I had a question.
Thanks for having us.
I appreciate your using the initial rollout period to educate us, because we're very confused. We already provide in our Dunkin' Donuts businesses up to 105 hours of earned paid time off. My employees are somewhat confused on how that's going to affect them because of the nature of our business's scheduling, and I need people to show up. I can't telecommute a cup of coffee to you. It doesn't work that way. And the burden falls on the people who do show up to work. We would probably just re-engineer our existing policy and pay out the time as they as they earn it. But if someone doesn't show up, would I need to then pay 2 people to do that job? I guess I need some clarification there. And
I didn't understand.
if they're getting their paid time off as it accrues, and then they call out sick, but they've already been paid, I don't need to pay them again. Correct?
If they have been paid, you have a record that they've been paid for,
Right.
it would cover that time, and
Okay.
and their job protections remain intact.
Correct.
Right.
Okay. Is there also a private right of action under the wage and hour law? So
There
during this education period, there will be class action lawsuits, despite the fact that all of us aren't necessarily clear on what our obligations are. That's a major concern of mine, and many others. And my other question was, you refer to Chapter 29, Section 207E, United States Code, and I assume that means people who are earning tips will not get a share of the tips. They will just get their base wage.
Well, as you know, in the restaurant industry, if you're paying the service rate as an employer, it's usually the tips that makes up the difference between the
Correct.
service rate and the minimum wage, which is now $9. So that $9 would be effectively the base rate. If someone's out, tips would not be included in any way.
So
So it would be $9 an hour for that employers would have to pay for restaurant workers who ordinarily would make the service rate.
in full-service restaurants like that, a common practice is everyone wants to work Friday, Saturday night, Sunday brunch. No one wants to work Monday lunch. So people commonly say, well, if you want Saturday night, you have to work Monday afternoon. Those people who agree to do that get first crack at the more lucrative shifts. Would that practice become essentially unlawful by having people just not show up for that and still get the Saturday shift? If you then say, well, you didn't work those Monday lunches, I'm taking your Saturday shift away and giving it to someone else,
So it's
that would seem to violate the law.
It's essentially like an attendance policy.
Correct. And that would seem to specifically violate the law and run afoul of the draft regulations. And I'm concerned that that's a very common practice in full-service restaurants. And my last question is regarding tip pooling. Under the existing law, which we've discussed at length over the years, if you're not actually serving customers, you can't get a share of the tip pool. And if you're not there, you obviously are not a service employee, you're not serving customers. My concern would be, how does that work?
How does that work?
How would that affect the tip pool? If a person doesn't show up and is claiming...
They wouldn't be sharing in the tips. They would just be
Got it.
getting minimum wage for every
Got it.
hour, unless they have a higher rate of pay.
Understood. Okay, thank you.
Okay, Thank you.
Sheila Bolston? Okay, thank you. Stuart Coleman.
Good morning.
Tough day to be inside.
We were going to hold it outside, but the parking lot was
I had
kind of
school
full.
outside today. All right, a couple of things. So I'm Stu Coleman. I'm a partner with Winter Wyman. We're a recruiting firm. Also a board member with the Mass Staffing Association. We'll submit our concerns in writing for you, so I won't be redundant there. Just a couple of points. As Richard spoke, we also have about 1,000 folks out on contract or temporary assignments, making 2,000 to 3,000 placements a year. The administrative function of being able to keep the time up, especially over the course of a full year, is burdensome, so we'd ask for some help understanding that there. And I think my biggest concern is with the regulations to make sure that we get them done right the first time. And I'll reference the temporary worker right to know law, where 2 years later we still have 3 pretty big issues that we recently spoke with the new director in that group and asked for a subcommittee of just, look, there's some minor points here, but they matter, and there is a private right of action in these cases, and we just need to make sure that we get them right because we want to be in full compliance. And I think as an association, probably contrary to public opinion, we completely understand these folks have earned this time and they should be able to use it. It was my opinion all along that the AG said, look, they're going to earn 40 hours, they're going to earn a week, and they're going to use it any way they want. And I think the way the rules are coming out, the regs are coming out, it kind of speaks to that. Sure, they have to sign off on saying that they were sick, but that's about the extent of it. So other concerns that you heard here today, minimum increments of time.
I just want to make sure there's no feeling from the Attorney General's office that you can use it any way you want. It's if bona fide use of the earned sick time
Right.
for the delineated purposes is all that's covered, that's all that's protected. Use for other reasons could subject an employee to discipline. And that we would want to be very clear about this. This is not vacation time.
Right.
And so
But what is the policing of that, other than the employee saying, I was sick? And what I think this speaks to, and the other point I'll talk about, I think Richard actually started to hint at it, are the unintended consequences. So on a day like this, where it's particularly nice and it's a Friday, and somebody's out sick, and that was a short-term assignment for a contractor, and that employer, so we're the employer, our client, not happy. Like, you know what, that just speaks to a lack of engagement, or whatever, you know what, I just don't want them back. And now suddenly they're unemployed because they felt they had the right to take this time anytime they wanted to. That's a bit of a concern. I think that's going to cost some temporary folks jobs. We're going to counsel them every way possible, try to make sure that they're doing it correctly, et cetera. I just think if there were a little more robust provisions as to, we need to make sure that these are being used for the appropriate manner. So, just a concern.
I mean, one of the questions that that I have in this case is, how do employers currently determine if someone's calling out sick and it's bona fide? I mean, that it's not
Right.
new that someone gets sick. It's part of the human condition that
Of course.
people get sick. So I guess my question sort of back to you is, what do you suggest by way of checking if someone's actually sick? I add that it's not. It's somewhat rhetorical, but
No, I get it. It's in the contractor, the temporary world, and this is definitely an issue. It's somewhat auto-correcting. If you are out sick, you don't get paid. So you have to make a conscious decision: is this serious enough that I don't go to work
Right.
today?
But now the law says if you're sick, you do get paid. So,
But they don't have to provide any form of documentation for it.
well, you can require them to sign post-use verification.
Okay. Again, it's to what level is that going to be verifiable? How much teeth does that hold, et cetera? And that's just my concern, where, and somebody mentioned before, they show up 15 minutes late, you know what? Pay me. I didn't feel well this morning, had a little bit of a sniffle. And it's interesting because I completely...
I also wanted to provide the clarification that just showing up late to work is not a bona fide use of earned sick time.
Understand.
Employers can implement their reasonable notification
Yep.
requirements, and just show if you're going to be late to work because you're sick, you have an obligation to let the employer know
Of
that,
course.
unless there's reasons that you can't do so.
Right.
So that, we hear this a lot. People are going to be coming in 15 minutes late all the time.
And they'll call on the way
That's-
in, probably, or when they do ultimately get up or out the door. You can't tell somebody I'm going to be sick tomorrow, so that you can't pre-notify on that. So I completely understand. We do deal with it every day, with 1,000 folks out on assignment. And I think that's just where I get concerned about folks losing jobs. A good example is there's a short-term assignment, say it's 2 weeks, 3 weeks, something like that, or it's been a longer assignment, the client says, you know what, we know that this is winding down, so we're going to need so-and-so until this date, and then we should be all set. That person has a certain number of hours that they've accrued with, in my case, Winter Wyman. Maybe they get placed by another agency, maybe we place them. I got 3 days coming to me. I think I'm going to take them at the end of this period.
Well, it sounds like you're constantly talking about lying, cheating employees, and we don't have. I don't know what to tell you about that.
Right.
That's,
And that's not the
that's not what the law. The law is not to be used if the law is being misused by employees. That's not protected. This is for bona fide use. This is to keep people from losing their jobs because they're sick, or losing a paycheck because
Right.
they're taking care of an elderly family member or a child. And if people are lying and cheating all the time, I don't know what to tell you.
The question is, if there is an opportunity for abuse, some people will abuse it. And so is there a way, and I don't unfortunately have a good solution, but is there a way for us to figure out to put more of a responsibility on the employee to say this is a bona fide use, here are the things that happen.
We can't, there are a lot of laws that protect privacy in the medical and health realm. That certainly puts hampers the ability to discern specifics. But to the extent that folks have input or feedback, ideas about what could provide some further, safeguards from misuse, we would love to hear about those. And please do give it some thought, because it's something that comes up a lot. And we empathize with employers who might have hired people who are dishonest, but that's, we're here to really protect the people who need it and who need the law and need the protections. And also, we don't want to have employers being cheated. So give it some thought and give us your feedback.
Yeah, where I struggle is somewhere between reasonable and draconian, because a tough one would be you can't take time off in the last week of an assignment. And that's rough. What if you're actually sick, right? So, so that's where I want us to at least be mindful. And I think it was Greg McDonald talked about the difference between a ballot issue and a legislative issue. We've worked very well with the Director of Labor to come up with ways for the temp worker right to know to be better implemented so that it helps everybody. We get it. You should get a job description and know what you're going to be paid and what your hours are. I don't know if there's been as much dialogue as we would have liked during this process. And I appreciate your statement saying, look, this year's a learning year and we're going to figure this out. I guess, speaking as a member of the Mass Staffing Association, we would like a little more conversation to help in that process.
Yeah, I mean, we have had, I had a 2-hour conference call 2 months ago with the Staffing Association, and we've had lots of feedback and input, and this process has been going on since January. There are, thousands and thousands and thousands of employers. We've been hearing from many of them, and so it's an ongoing process. The regs have been greatly informed by the contributions and feedback from employers, and so if there's more, please provide that.
Yeah, and I mean, I anticipate that the office will continue to provide materials and FAQs as issues arise. I mean, as issues arise come July 1st and questions come in, there will be sort of even further development of materials to clarify issues. I think, we can't have regulations that answer every single permutation of every question, but provide, I think, bright lines as best as possible, and then continued development of materials and guidance. Through our engagement with all of you.
Great. No, then I'll take you on your word for that if we can continue to be a part of the process, because again, we want to be in full compliance and make sure it does work for everybody. So
that's our charge from the Attorney General, so we will be doing it.
Okay. Very good.
Thank you
for your time.
Thank you.
Jenny R.
Good morning. Good morning.
Good morning.
I will be interpreting.
Okay. Thank you.
I'm making an introduction.
Thank you.
Good morning. We are members from the group Neighbor to Neighbor. First of all, thank you for holding these meetings for our community can voice their opinion. And Neighbor to Neighbor is a progressive, multi-ethnic, multiracial organization working in communities of working class, and we ensure that all families have equal opportunity to economic and social justice. We are part of a coalition, Race of Massachusetts, and last year we collected more than 350,000 signatures across the state. Hundreds and hundreds of organizations part of this coalition made more than 1 million calls and knocked thousands of doors to ensure that voters have an informed vote for the election. And more than 60% of voters voted yes on the question 4, so every worker in Massachusetts had the opportunity to earn sick time. And nearly 1 million of hardworking people in Massachusetts, almost 1/3 of workers, can't take a single paid sick day and risk losing their job if they have to stay home to care for themselves or a sick child. These workers are often forced to choose between going to work, sick, or losing a day's pay. They send their sick kid to school because they cannot afford to take a day off to care for them. This cannot continue. They shouldn't have to choose between the job they need and the child they love. They must be able to take their child or their aging parent to the doctor without worrying about being fired. Last year, a majority of voters, like I said, across the Commonwealth, voted to provide sick time to millions of workers, once again placing our state laws in the step with our people's values. Hardworking people cannot afford to wait any longer to earn and use sick time. Right here on my left, I have Jenny Rodriguez, one of our members that have a testimony to share. As you can see, she cannot work at this point. Jenny, please give me a chance to translate.
Buenos días.
Buenos días.
Good morning.
Mi testimonio es hace yo 3 semanas.
My testimony is that 3 weeks ago,
Yo era una persona normal,
I was a normal person,
trabajando como home health,
working as a home health care,
cuidando personas con discapacidades,
taking care of people with disabilities,
apoyando al grupo Neighbor to Neighbor como voluntaria,
working as a volunteer in the community with Neighbor to Neighbor.
También miembro de la unión de las PCA.
And I'm also a member of the Union of PCA, que es el SCIU
1199.
SCIU 1199.
No sé si es para bienestar mío o desafortunadamente tuve un accidente.
Unfortunately, I have an accident.
Y se me cerraron todas las puertas.
All doors closed for me.
Me sacaron del hospital al 3er día porque mi seguro mi seguro es MedHealth. Voy a cumplir 4 años de ser residente en este país.
It's going to be 4 years that I'll be a resident here in the United States. When I had this accident, although I close to me, I couldn't even stay in the hospital for the care I needed because I had no insurance.
Yo trabajaba más de 60 horas en mi trabajo, pero estaba catalogada como un part-time.
I have no benefit because even that I work sometimes up to 60 hours or even more at times, I am a part-time worker.
Y ahora me encuentro, ustedes me miran acá, yo no tengo beneficios de nada, no me cubre la compañía para la que yo trabajaba no me ha llamado.
Being a part-time worker, I have no benefit at all, and I haven't even received a call from my employer.
Ahora me encuentro en una situación muy, no sé cómo decirlo, una situación devastadora para mí, porque las personas que dependían de mí son las que ahora me cuidan, que son mis hijos, una niña de 14 años y un niño de 10.
This is a devastating situation for me. I used to be the caretaker for my family. Now I depend on my family to do everything for me.
Yo lo que pido ahora es de que lo más pronto posible se implemente los días de enfermedad, porque nosotros no somos, los empleadores se lucran de nosotros, pero nosotros no tenemos ningún beneficio.
I ask that the new law for the workers for sick time will be implemented immediately, so people like myself who have no benefits can have some basic sustainability, like have something to take care of them.
Eso es lo único que yo pido, que se abra que sean conscientes y que ahora estamos bien. Mi vida cambió en un segundo, y me encuentro sin ayuda de nadie, sin ayuda del gobierno, porque no aplico. No me aplicaron tampoco los food stamp. Me vieron con mis manos quebradas, con mi nariz con puntos. Y no me ayudaron. No me han dado ni cupones de alimentos, nada.
I have both hands useless. They broke with the accident, and I had no access, not even to food stamp. And she asked that, as a human aspect, something needs to be done, because you can be well today, and then next day you don't have the same ability that you had to be self-sufficiency like her. And she asked that the new law be implemented. And this is to close. She asked to the Attorney General Maura Healy to please implement the new law immediately in July 1st as requested by voters for safety net and as a human right that voters claim on election, and to respect and to really get the voters' decision implemented. Thank you so much for your time again, and please have in mind that Jenny's story is only one of millions across the state. She is here to speak on behalf of every single of them. Thank you.
Okay, thank you.
Gracias.
Gracias por su testimonio.
Just so folks know, there had been discussion about delaying the implementation of the law, but the legislature took that up on a vote and declined to delay the law. So the law will be going into effect on July 1st, as the voters had instructed. Okay.
Thank you. John Grossman.
Good morning.
Good morning.
My name is John Grossman. I work for the Service Employees Union, Local 509. Our union represents many workers in the human services and education field. We have been strong supporters of the Earned Sick Time law. And I want to speak today with reference to a particular group of our members, which also represents a growing number of employees in general. And those are clinicians who are paid on a fee-for-service basis. Many clinicians, in our case, I'm referring to people who provide behavioral health services, whether it's counseling of various kinds, and these might be social workers or psychologists or nurses. Many of them are now paid on a fee-for-service basis, which means they're not paid for each hour they actually work, but they're paid for each billable unit of service they provide. They work their agency bills, and they get a portion of that. So, for example, if you were a licensed independent clinical social worker and you provided outpatient therapy, you might be paid $36 per billable hour. So you get $36 for each therapy session, but you spend a lot of other time doing additional work, such as documentation, calling family members, other caregivers, traveling, or whatever. And if perhaps your client doesn't come in to see you, you don't get paid at all. So it's kind of like piecework in human services. We represent several hundred clinicians who are paid like this, and it's a method that is very commonly used to compensate clinicians in Massachusetts, and I'm sure other employees as well. Most of these folks don't get any paid leave time at present, and that's a real benefit. This law, I believe, will be a real benefit to them. I want to address briefly the argument that is made that because they get paid more than salaried employees who do the same work, therefore they don't need the paid leave time. And the main point I want to make is that they do get paid more than salaried employees who do the same work. Number one, neither one of those groups gets paid very much. These folks are, one study we did, it was between $38,000 and $39,000 projected out over a year, and those are people with master's degrees and licenses. But more importantly, or equally importantly, the higher rate they get compensates them for the time they spend doing work that they can't bill for. So although there's a confusion when you say they get $36 per billable hour, the billable hour encompasses a lot more time spent doing the other work, the documentation, which is always increasing, as everybody here knows, and other collateral work they have to do. If the weather's bad, clients don't come in, they don't get paid. If you work in behavioral health, you know that there are people that are not entirely enthusiastic about the services they need, and it can be a high no-show rate. So people will work more time than they're able to bill for. A full-time clinician, in my experience, rarely can bill for more than 23 hours a week. And like everybody else, they get sick, and when they get sick right now, they don't get paid, or they have to choose between not working and not getting paid, or working and not being well, not providing good services. And these are folks that work directly with people, often children and families. You don't really want them being sick going to work. Nobody should have to be in this position, and I think this law is a major step forward. And we want to make sure that the coverage is extended to folks in this situation. Thank you very much.
Thank you. Wendy Morin. Okay. Luz Vega. Okay. Chris Cuden?
Condon.
Condon.
Yeah.
Thank you.
Okay.
Thanks. My apologies.
It's okay.
Sorry. Very briefly, I didn't realize I'd be going up right after my colleague John, who spoke specifically about one group of workers we represent, but I'm with SEIU Local 509. As John mentioned, we represent a wide range of workers, many of whom have very unique circumstances and don't fit into a narrow box of going to work 9 to 5, 40 hours a week. And we just wanted to applaud the work of the Attorney General, all of our staff, in working, we think, in a very real and sincere way to comply with the spirit of the law. There's a lot that you guys have to tackle in terms of figuring out how this law will work. We think you've done a great job. We think you've struck a good balance. The will of the voters was overwhelming in every part of the state, in cities, in towns, older voters, younger voters, in every demographic you possibly look at. And you've embraced that and have tried to do this in a way that will make the law work for everyone. And we just want to say thank you.
Thank you for your thoughts.
Sue Mailman.
I thank you for coming to Worcester too. I haven't heard anybody speak about the construction industry this morning. My company has been in Worcester since 1885, union electrical contractor, and I guess it's a couple of comments about the unintended consequences. I voted for Attorney General Healy and believe in what we're looking for here, but our company every day is competing against companies that don't pay any benefits. We have collective bargaining agreements that have middle-skill, high-skill jobs with fair wages and work often with neighbor to neighbor and some of these other groups. And a couple of clarifications. I do think there's a group that's already exempted until January 1st from the law. And I think all employers should be. So that's one of my statements. We should just push it out until all of these questions and concerns are resolved,
Right.
because there's still, just talking today, you can see there's a lot that's not.
Okay, I just wanted to clarify that no one is exempted from the law. The laws will be in effect on July 1st as to everyone, but those employers who already have sick time policies that might have components that don't completely jive with the way that the regulations.
Sure, and a
right?
lot of those employers are really large employers, and there's many of us that are kind of middle employers that have good construction jobs. In our industry, these rules are very complicated. As you know, we have people in other states, we have people working part-time. Our office staff feel that this is like a regression of benefits. We have a
Do you have sick time?
we have a
and-
paid leave policy.
Okay,
Yep,
so-
that is higher than what the state offers.
And what? So it sounds like you would probably be within the safe harbor then.
Not from my understanding is no right
why,
now.
Why is that? If you have paid time
I don't
off-
know. I'd say you're both the industries that we're part of, which is the Associated Subcontractors of Massachusetts and the Associated Industries of Massachusetts, have asked for an extension for all employers until January 1st, and I'm just here to echo those comments.
Right. Well, so
and then to
let-
also echo the point that the union construction industry is being made more uncompetitive with the new regs.
Okay, let me just tell you that, one, it's the legislature that, as I was saying, has the authority to delay if it wanted to, and it voted not to delay.
Right.
We have no authority as the Attorney General's office to delay a law that is both
Fair enough.
effective, et cetera.
Yeah.
And if you have paid time off policy, there's a very good chance that you're covered by the safe harbor provisions. If folks haven't already seen the safe harbor provision, there's a copy up at the table.
But
And-
my 300 union electricians do not have sick time in their collectively bargained agreement.
Do they have vacation time?
No.
Do they have personal time?
No,
Do they have, so they don't have paid time off?
they don't.
Oh, I thought you said they did.
My office staff does.
Oh, your
My
office staff
union,
does.
electrical,
Right.
construction workers do
So
not.
these
And
are-
they've bargained in good faith for wages and benefits that are, very good wages and benefits. And we're
But they
trying
don't
to
have
work with
time
groups
off.
like this to bring people into apprenticeship programs. So I asked one more time for, the employers in the state that are getting it done already are being impacted, and the unscrupulous contractors that I compete against many times are likely going to take the safe harbor or whatever ways they can, as you pointed out earlier, to skirt the law. But law-abiding citizens that have been here in businesses for a long time are going to be impacted right
Well,
now. That's the only testimony that I wanted to provide today.
Well, the safe harbor only applies to employers who are already providing paid time
Understood.
off to their employees.
Understood. So two different components of what I'm asking. A lot of push out for everybody that is providing it. I know it's legislative. And the second thing is to, just to echo that collective bargaining agreements have been bargained in good faith, and it seems not the unintended consequences of this law are impacting our construction industry. Thank you.
Thank you. Marilyn Haddad.
Good morning.
Good morning.
My name is Marilyn Lopez Haddad from the Seven Hills Foundation. First, I'd like to thank you for giving us the opportunity to provide oral testimony regarding the proposed regulations on earned sick time. The Seven Hills Foundation is a human services nonprofit parent organization to 11 individual operating affiliates, and we offer a continuum of support and services to over 28,000 adults and children with disabilities and other life challenges throughout Massachusetts and Rhode Island. We employ approximately 3,700 employees throughout Massachusetts and Rhode Island, 2,500 of which just work in the state or the Commonwealth of Massachusetts. First, I'd like to emphasize that Seven Hills, like many other human services providers, do support the decision to provide access to earned sick time to employees that did not otherwise have access. Our direct support professionals in particular work with some of the most vulnerable populations in the Commonwealth, and we're pleased that all employees will have access to paid benefits during times of need. We do have, however, some concerns with the proposed regulations and the time between the issuance of the final regulations, which you indicated would be June 19th, correct? And the July 1st effective date. First, I'd like to just address the financial impact to our organization. The cost of providing earned sick time to every employee pursuant to the proposed regulations will be significant for organizations like Seven Hills Foundation and other human services providers. In our organization alone, we have over 700 part-time employees. This includes many per diem, or as they're referred to also as relief staff. And it's important to note that many of these part-time employees work for multiple organizations where they will now also be accruing time. And they also have full-time jobs in other organizations where they do accrue or benefited time. Our business office estimates the total cost. And granted that this is a worst-case scenario, to Seven Hills will be over $245,000 per year. Now, this is a tremendous impact to already what we believe are already underfunded, I should say, programs.
Can you explain what the cost is about?
Essentially what we did is we currently do offer sick time based on a full-time benefits eligible status. So we went through and we have various payrolls, so we went through our various payrolls to determine the impact if every employee would use the accrued sick time for 1 year. So it's the total number of hours divided by the 30 times the hourly rate, essentially, and that's how we arrived at that figure.
So that's like if
everybody did
took all their benefits.
Right, and we understand that not everyone will, and I've been in the HR field for over 20 years, and I know that there are many deserving employees who do use their time. They value it and see it as a benefit and only use it when they need it. But as others have said, there's also the potential for abuse, and we do see that, unfortunately. So it's very difficult to say what the exact cost will be until you've actually had it in place for a while, and I'm sure that will vary from year to year. But I still think that it will be a significant cost. I believe someone also mentioned earlier the cost to adjust our time and attendance systems, and again, mentioning different payrolls. There are some payroll for relief staff, which we'll have to make some adjustments to, and we're still in the process of trying to figure out the tracking and the reporting to the staff of that time. There have been some questions regarding some of the language, and Seven Hills, like many organizations, relies on adequate notice from our employees if they're going to take time off from work. Again, many of our programs are staffed 24/7, and even with several hours of notice, sometimes it's very difficult to find coverage. Our supervisors may come in and fill in shifts whenever they need to. But again, even with several hours of notice, it's difficult to find employees to fill every shift. The proposed regulations mention in this section, the notice provisions indicate that an employee shall make a good faith effort to provide notice of the need, or that they must provide notice as soon as practicable. And we certainly don't want to run afoul of the regulations. But I think that these areas need a little bit more clarification, and it varies from program to program. So our day programs may have a little bit more flexibility in terms of the notice that they require, whereas our residential programs, in particular if they're in some remote areas, it may be much more challenging. So, we don't, like I said, we don't want to run afoul of the regulations. So I think that we just need a little clarification in terms of the definitions in those sections. Another area that I believe was mentioned was the documentation section 3306, and this section provides that employers may require doctor's notes after an absence of more than 24 consecutive hours. Some of our part-time employees only work 2 hours, 3 to 4 hours. So I would imagine that there probably will be situations where an employee is out of work for perhaps even over a week before that they would hit that 24 consecutive hour. And I'm wondering if that was the actual intent.
That's actually in the statute.
Yes.
The 24 hours is statutory. We are planning to revise with respect to those employees who don't work full-time, that rather than 3 days, it would be 3 shifts. So if there are shifts that are less than 8 hours, for instance, 3 shifts in a row, after which that would give employers the right task for documentation.
Okay, thank you.
Just look for that in the final regs.
Okay, thank you, because that was going to be my suggestion. There's also the section regarding the signed written statement in lieu of a doctor's note. The regulations say that the employers may use the Attorney General's model form. It's not clear what would be acceptable if an employer opted not to use that form. Or will there be some guidance on what would be acceptable?
I'm sorry.
With regards to the signed, there's a provision, I think it's 33062, signed written statements.
So just post-use verification?
Yes, in lieu of a doctor's note.
That was that. If you look at the statute, there's only one line that says anything about employees needing to give notice. So we have actually built a lot of meat into sort of or fleshed out that concept by giving a lot of as many safeguards as originally we thought was necessary. We're obviously working on adding some additional considerations, but that was just to facilitate, small businesses' ability to have some access to a form. They might not have HR, and here's a form that they can use. You can have your own form.
Okay.
But it's taken into consideration that you can't ask about the nature of an illness, and there are other safeguards with respect to privacy that we're bearing in mind. But that was just a suggested sample. You don't have to use a sample at all. You don't have to have post-use verification, or you can.
But there is the option for if an employee does not have a doctor's note to provide some other form of written notice. And so, is there going to be more clarification on what would be acceptable or not, or is it up to the employer?
In terms of certification?
Yes.
We intend to be fleshing out what it means to not have a healthcare provider. It's not, we discussed this a little earlier with someone else there, it's not a sort of catch-all, like I didn't feel like going to the doctor, so I'm just going to sign my own note. There are going to be other sort of restrictions around what it means, or other information to describe what it means to be an individual without a healthcare provider in the regs.
Okay, so some consideration or thought could be given also to that what would be an acceptable signed written statement. It doesn't. You've indicated you'll address the issue of what it means not to have a healthcare provider, but then the statement itself, what would be acceptable, and can an employer make that determination? So. We're also not clear on the impact of the proposed regulations on relief pool, and again, these are the staff that only work a number of shifts. But I believe you said that there's going to be some consideration given to those types of individuals. And the relief staff are, in some cases, individuals who have no scheduled shift, and they may come in perhaps just to cover a shift on minimal notice. So how will they use that time if they are accruing time, if we post out a vacant shift, 4 hours, let's say, to 4 relief staff, and all 4 say, we're available to take the shift, and or one says, I would have taken it, and I'm perhaps the more senior person, but I'm sick. Does that mean they get to use a sick day for a day they weren't already scheduled for?
I think if someone is not on a schedule and they're called in, the Sicktime law would, if they get sick, or their child's sick, or their parent's sick during the course of the shift, that protects, that gives them the right to leave and take care of their health care related needs. So, but if they're not scheduled, I think you're probably going to have a situation where if someone can't work, isn't scheduled to work, they wouldn't be able to exercise a right. If they were scheduled to work, that's a different situation.
Okay, and then again, I just ask for some thought to those types of employees who don't have a regular schedule, and in many instances, they'll be called in that day or the night before to come in and cover a 2 or 3 hour shift. So, And it's really difficult for us as employers, I'm sure, as well as you, to try to identify all the different types of scenarios that'll play out. And I understand that and appreciate any guidance and the proposed guidance you said that employers would receive over the course of the next year. On behalf of the Seven Hills Foundation, and I'm sure, no doubt, other human services employers, I just request some consideration. A couple of people have already mentioned a delay in the implementation. Again, I know that's not your decision, but I did want to get that on the record. We do have many managers that still need quite a bit of training and notifications to staff, adjustments to time and attendance and payroll systems. So, it's going to take a lot of work, and we will have a minimal amount of time before this becomes effective. So, again, thank you for your time, and we appreciate your consideration.
Thank you. Ademola Odubi. I don't think I did very well with that. I'm sorry.
I think you did pretty well. Did he? All right.
Okay. Good morning. You can bring it up in the back when you're done.
Okay. Good morning. My name is Ademola Odubi.
Good morning.
I am here to testify. I am a member of the SEIU Local 509, and I work in human service field. I've been working in this field for so many years. I work with developmental disabled in the residential programs. Our pay is low, and therefore I have to work more than one job. One of my jobs is relief job. Relief, or per diem as they call it, we work on as needed basis. We don't have guaranteed hours. We work when employer needs us to fill the holes in their schedule. One of my jobs, I work more than sometimes 50 hours in a week as a relief, and I don't have benefit. Some of these agencies, for them not to pay benefit, they keep relief worker on duty rather than employing full-time staff. And if a relief asks for full-time position, they will not give it on time because it pays them to hire relief staff. Many human service agencies use relief staff. They use us to fill regular or part-time hours. Sometimes regular staff call at the last minute because probably they are sick. But more frequently, relief staff fill planned absences. Some people might be going on vacation. Some people might call in for FMLA among the regular staff. They call a relief staff to fill it. One of my jobs, I pick hours in advance, sometimes in advance of 2 months as a relief. Because they put the schedule out, you pick it up because they know their staff going for vacation. We fill in this sheet where employees are on vacation medical leave. We fill in sheet where employees have quit and they have not yet employed new ones. Some employers never fill up the shifts with regular staff. Instead, they prefer to use relief staff because they save cost of paying benefit, vacation, sick time, all those things. Most of relief sheets I work are often signed up in advance, like I said. And then if I get sick one day, I have either to go to work while I'm sick and get my client infected, or I stay home without pay. One particularly happened to me. I was on schedule, and my wife was pregnant. She broke her water. She had to go to the hospital. I called the ambulance. I had to go to work. I didn't know that day she's going to put to bed, but I had to go to work. I was at work when she put to bed in the hospital. I'm a relief staff because I have a permanent schedule that I have picked. I count on my income as a relief staff to pay my bills because one job will not sustain me and my family. And as I speak, working on average certain amount of hours each week. As a relief, I work 40 hours a week in my second job, even though I have a full-time job. And this is true for most of relief workers I have met. For us, working relief is a second job and sometimes a primary job because I work at least 40 hours as a relief. we need to earn sick time just like everybody else. That's my submission. Thank you.
Thank you very much.
Suzanne Chung?
Hello.
Good morning.
Good morning. I'm Suzanne Chung. I'm Director of Human Resources at the Worcester Housing Authority. And our request today is that the final regulations include a provision that housing authorities are subject to the provision that as if it's a city or town in which we would opt in or our board would opt into the law. There are several areas of laws in which the housing authority and its employees are treated as if it's a municipal agency or as a city. For example, the employees of the housing authority are treated similar to employees of the city of Worcester for purposes of the retirement system. For cities, the appointing authority.
Can I ask, when you say like them, are they in the same pool?
Yes.
Okay.
There's different rules if you're a firefighter or a police officer or a teacher, and different rules for housing authority employees, but the city's retirement system is the same. We're treated the same. In addition, the conflict of interest law applies to the housing authority employees as well as to the employees of cities and towns. The housing authority employees have to follow the same annual conflict of interest law as city and town employees. And actually, the appointing authority for cities, for the city of Worcester, 4 out of the 5 members of our board are appointed by the city. So for those reasons, we're requesting that housing authorities, it's not specified, but that housing authorities are considered as if it's a city or town to choose the opt-in for purposes of the earned sick time law.
Do you know, generally speaking, what type of leave policies housing authorities across the state have?
I don't know about other housing authorities. I'm guessing that they're generous, like the Worcester Housing Authority has a very generous sick time policy and paid time off policy. Each employee, except for certain categories of employees, earns 12 days of sick time a year. The people that do not get earned sick time are our temporary employees, or we have several apprentice training programs, and those employees do not earn sick time.
And is your funding through the rents and federal allotments?
Yes, and state allotments.
How does that, is there any interaction with the city's budget?
No.
Thank you.
Thank you very much.
Carolyn Santiago. There's some seats up front if people need to come around.
Thank you.
Good morning. Good morning.
My name is Carolyn Santiago, and I'm a personal care attendant from Worcester. PCAs like me help seniors and people with disabilities live in settings of their choice with dignity.
Okay, excuse me, can I have you pull the microphone a little closer, just for so that you could be heard well? Thanks.
I help ensure that my consumer has the most independency possible. I am in her home often, working to take care of her needs. Until this law was passed on November 1st, I had no access to sick time. I either came to work risking exposing my consumer to whatever cold or flu I had, or stay home without getting paid for the day. I need my paycheck to meet my most basic needs. This has been an impossible choice until now. I want to thank the Attorney General for working so hard to implement this law. We worked very hard to ensure nearly 1 million workers, many like me, have access to sick time. This is now reality, and I'm here in support of strong. We cannot wait any longer, and fortunately, we do not have to wait. Thank you for your time, and thank you for ensuring this law moves forward without any delay.
Thank you very much.
Thank you.
Vicki Smith.
I knew you were going to call me because I was just jotting my notes down. So I work for a family-owned payroll company. We have hundreds of clients. One of the things we pride ourselves on is personal service for them. So that they are not having to make phone calls to the government, we try to make sure we are on top of all the laws and regulations out there, understanding that it's ultimately their responsibility, but it's a service that we want to provide for them. So there's just a couple of things I want to make sure are clarified in here for them. And I was also involved when we did the fair share contribution. We had a lot of clients that were kind of on that 11 full-time equivalent cost, but I know it's different now with number of employees. But we've been going back and evaluating who's going to have to do paid or unpaid or whatnot, because also a lot of our clients have part-time employees. And I found, in looking through like old DOA reports over the last 2 years, that we have some clients who have gone from 12, 11, 10, and now they're steady at 8. But still, if you look at the 2-year period, they may have had over 11 in that first preceding year. Can you clarify in here whether or not, if someone's maybe in the last 6 months, 8 months, 9 months, and maybe unfortunately it happened because of this law, they have reduced under 11, are they going to have to roll this out assuming that it's paid because they were over 11 in the prior year? Do you know what I mean?
Yes.
So if you could clarify that in the regulations for us.
And just for the transition year purposes?
Yeah, and then even, I assume going forward, as I've read in here, they will, as soon as their status change, they will notify the employees and then switch over. And then there's something else in here that's kind of related to that, where it talks about, what's in this regulation?
Well, and if it's earned as paid sick time, you have to pay it out as paid
until that's used up,
Yes.
and then they would switch to or unpaid or whatever, or vice versa.
Yep.
But on number 7 and 3304, number 7, if you could have that clarified too, because it says when employee has both unused, earned, paid, and unpaid sick time available for use, which might be the situation. And again, we have a lot of clients that go back and forth like this. The employee has the option of either using either or both. Is there a one comes first? Like if it was earned first, you have to use. If you were going to pay out first, you were in a pay status company, then they're going to get paid first, or do they have the option of choosing?
If they have both on the books, they can choose.
They can choose which one. Okay. And then on the safe harbor, I know everyone's gone back and forth, and I just want to make sure we're directing them right. Most of our clients that are over 11 are all set. They've been providing it. However, not for part-time. So if they're in safe harbor, they will now need to still add those for the remainder of the year. It's not like they can continue. I think you've said a couple times they can continue with the policy they have. They really can't. They have to add all those people on, including like a co-op student from Northeastern, let's say, right? If they're there over 90 days. Okay. Churches, is that they're considered nonprofits?
But they're employers.
If they're employers, we do have a lot. There's nothing in here on the whole religious piece of it. We do have a few of those. Where reverends are getting paid and whatnot. Maybe that could be something you could try and...
There's no carve-out under this law specifically. Under the minimum wage law, there are certain carve-outs for religious organizations.
So this applies to churches then as well, because they would fall under a nonprofit?
Because they're an employer.
Right.
Because they're an employer?
If they're an employer, they're an employer.
Yeah. Okay.
Right.
Yeah, the tax status of the employer is not relevant to whether they're covered by the earned sick time law.
Okay. And then lastly, we have a lot of, because we're actually in the Chelmsford area, so we have a lot of companies that have New Hampshire employees. Those New Hampshire employees are also getting sick time from the Massachusetts company, correct? Doesn't matter where they live.
Are they?
They're working in Massachusetts.
Yeah, they're working in Massachusetts, yeah.
Okay. All right, thank you.
Thank you. Bridget Quinn.
Hi, good morning.
morning.
My name is Bridget Quinn, and I work for SEIU Local 509. And I worked on the Earn Sick Time campaign with countless volunteers who gathered thousands of signatures and knocked on thousands of doors and talked to thousands of voters to ensure that every Massachusetts resident has access to earned sick time. So people no longer have to risk losing their jobs because they need to take care of themselves or a sick family member. And this issue is especially important to me because this past winter, my husband lost his job because he took 3 sick days. He worked as a manager for a commercial property services company, and he was asked to move a piece of heavy equipment. And when he told his employer that he needed safety equipment to do that and additional staff, his boss screamed at him to get the job done and hung up the phone. So my husband, being a team player, did the job, and he hurt his back. He came home and went to work the next day. By the time he got home that evening, he couldn't move his neck. So I threw our 4-year-old into the car, and we drove through one of our epic blizzards to the ER, where a doctor promptly told him, put him on bed rest for 3 days, and gave him a note for his employer. So after those 3 days, he went in right back to work, not because he was better, but because, he was a team player. He was promptly told that he was fired, and because he did not have a commitment to the company. No family should have that experience ever. And this is why full implementation of this law is so important. And I just want to say that we're really grateful that the Attorney General has taken a methodical, fair and balanced approach to promulgating the regs. And thank you very much.
Thank you.
Can I ask, did your husband get workers' comp?
We didn't file for workers' comp, no, because it wasn't a long-term injury. But they did tell him they wouldn't contest his unemployment and that he should be thankful for that.
But he was fired because he was injured on the job.
He was fired because he was injured on the job and had the audacity to take 3 sick days.
Well, if you want to talk to somebody in our insurance workers' comp division, if you're interested in learning more about his protections, this is my card.
Thank you.
Okay.
Lawrence McCarthy.
Morning.
Good morning.
How are we doing?
How are you?
Good. My name is Lawrence McCarthy. I work for a company called J.H. Lynch & Sons. We're actually a Rhode Island company, but we employ over 100 people in Massachusetts as well. We're in the heavy highway construction business. We find that some of these proposed regulations actually provide more uncertainty than guidance. And at the outset, the way I read the law, it seems to suggest that the AG's office may adopt regulations. It didn't say they had to. They only had to adopt regulations for record keeping. So, given the permissive nature of that grant, we submit that some of these regulations go too far. For example, I saw in Section 3303, the 90-day vesting period. I think it's on page 8. I think that provision actually is contradicted by the law. The break in service, the 1 year, that's nowhere in the law. I think that came from the AG's office. I don't think the 1 year provision is in the law. The definition of, I think the word is same hourly rate. I don't believe that's defined in the law. And it appears that in the regulations, it says the hourly rate is the base wages. Then it says plus, quote, any other benefits paid or accrued on an hourly basis. There's no definition of what those benefits are, to whom they're paid. We have over 150 union employees that have bargained. They're being paid under an agreement that's been bargained for. Some of them are paid close to $80 an hour. And when they bargained for those rates, they knew they were getting no sick time, no paid time off. They're seasonal employees. I believe, given the fact that the Attorney General's office has taken the position to go beyond the law, I think those people who are being paid under agreements, knowing that they get no sick time, being paid a rate based on having no sick time should be exempted from this law. Thank you.
Thank you. So that's the end of the list we have for people who want to provide comments, but if there are others who we missed, and then if there's anybody else who wants to testify, and then we can break and we can take questions separately.
And you had signed up but had just questions? Yes. Yeah. Okay. Why don't when we get, we'll take a break, but why don't you come up first since you had signed up to testify? Okay.
Anyone else to testify? Okay.
Oh, okay.
Yeah.
Come on.
Good morning. I think we're still in the morning, just barely.
Thank you. My name is Kevin Hincamper. I am a special transportation provider here in the state of Massachusetts. We transport school children, predominantly those that have special needs or are homeless or considered homeless. My concern that I'm raising today is the application of the law as it relates to the safety of the students that we transport. As it's been mentioned, there's been applications in terms of benefits and cost and all of those other items, of which our company, I think, does a pretty good job in taking care of our employees and making sure that we treat them correctly. But in our particular case, under the law as I understand it, a person who works 30 hours per week can accumulate one benefit hour for every 30 hours. In our situation, it would be helpful to define the word shift. We operate it both in the morning and in the afternoon. So if our driver were to go out for 2 hours in the morning, at the end of every 2 weeks, they would have the capacity to take, depending on the increments that you're going to identify for us, they can eventually take that shift off. And so every 2 weeks or so...
You mean use sick time?
Use sick time, I'm sorry. Use sick time for those times. And so there's two pieces to that concern me. One is that we do quite a bit of analysis with our families and our parents and our school administrators. And the number one concern that they have, and they've had this for all of the 13 years that I've worked in this field, is the consistency of the driver or the monitor with their students. So this opens the door for a number of inconsistencies on a very routine basis. Whether that takes place or not, we don't know, but we do know that we manage it every single day that we put these children in our vans and take them to school. The second...
your employees don't get sick ever?
Oh, they do. I understand, and we...
But why would this change that?
I think the comments that have been made here, too, is the practical application of the law. While we think we have good employees, any person that has a number of employees will face those that would use this as an opportunity to take time off. And because of the sudden nature of it, which is our drivers would report this to us possibly at 5:45 in the morning, any number of those would then require this to happen, which is the substitute driver. And the substitute, not only does it have an impact on the student who, again, has certain specific needs that are communicated to our driver. We've now placed them over time out with a student that they may not be familiar with. And the second piece about doing that on a routine basis is, again, we've seen this over many, many, many years, is about placing that driver in an unfamiliar situation. Traffic, time, locations, everything to do with their driving. So it's just a less safe situation. Again, we've managed it and we'll continue to manage it regardless of the law as best we can. But I think the implementation of this is going to have an impact on those families. It's going to have an impact on our company. So like others, I would ask for more time, I guess, for us to understand and get the rules and implement those. People have talked about January 1st as being, that would be helpful to all of us as employees, as an employer.
Do you right now provide sick time or paid time off?
No, not on our books. Okay. We actually offer other benefits, for example, bonuses for good attendance, performance, all of those things. We have a retirement plan for all of our part-time employees. So I think we have a good working relationship with them. This just could be a complication for us and for the students.
Right. Just to sort of reiterate, as it stands, the legislature already declined to delay the implementation, so it is going to be implemented on July 1st.
I'd be interested in the shift definition, because if the shift definition were different, I can understand if a normal shift were 6 or 8 hours long, so it would take a greater or longer period of time. But in our particular case of a 2-hour shift or a 4-hour shift, the frequency of that availability will cause us, that substitution and putting the drivers and substitutes on a more frequent basis. In my case, I think it would add up to about 9,000 situations per year where that's going, that potentially could take place.
I think that this scenario is specifically addressed in the proposed regulations insofar as you need your drivers to be at a specific place at a specific time to work the entire shift, right? Because if they're late, the bus has to go, right? So you can require them to take the entire shift in sick time, even if they're going to be, half an hour late or something like that.
We have to move. We have about 6 minutes of a window to be there. So whether it's a 15-minute window or a 2-hour, we'll have to see if you can consider the shift, the definition of a shift.
Give us some ideas of what you think would be workable for a situation as yours.
I don't know what the original intent was, but I would guess that it's for a person who may work an 8-hour shift, a regular day. And so if I were to apply an 8-hour shift to this, it would take a person, say, 6 weeks for them to build up to a day's worth of work in that time. And so that would, I think, reduce the tendency for a person to miss an entire 2-hour shift. So if the definition of shift were more defined, that would be helpful.
I mean, right now, the way that law is written, it says the smallest increment.
I know, yeah.
So we are, we're building in some additional meaning to that to make it more workable.
Right.
But you're saying a whole day is what would work in your.
I would say so, and I understand. I'm in a unique situation. In my situation, one driver, one van, one route. So it isn't as if when I worked in another place, when I worked in warehousing, if a person didn't show up, we'd cover these things just with existing staff. But we're picking up special needs students with an unfamiliar person in an unfamiliar area, and it's practical. It's what we do every day, and we know what has happened.
Very good.
Okay?
Thank you.
Thank you.
Anyone else for testimony this morning?
There's one gentleman over there. Morning.
Good morning.
My name is Brian Jansen. I work for a manufacturing company in Massachusetts, and I have two issues I'd like to bring up. There's one related to holiday pay. Many employers in the state have a policy where if you don't report to work the day before, the day after, and my understanding is that if they call in sick and have earned sick time, that they cannot be penalized for the holiday. If that's true, I'd like to have that reconsidered. There's some people talking about just changing and making a loophole to call it a attendance bonus, where if you didn't show up the day before or day after and were paid, that you would not get your attendance bonus opposed to holiday. So many companies have that policy. It should just be retained as able to be you'd have to pay for the sick day, I understand,
right,
but you shouldn't have to pay for the holiday if somebody calls in sick. The second item is, I understand you're going to clarify the increment of time, which is very important, because if it's the minute, it's the quarter hour, it's the hour, however it's going to be clarified. I would request that that be clarified before the 19th, because that's a pretty important item in drafting new policies as to how that works. So until we have a clarification on that, for sure, it's really hard to finalize a policy, because that very much integrates with the company's attendance policies
And
how that works.
How does your policy work now,
As far as attendance policy?
as far as increments of time?
We give, for paid time off, we do it in 8-hour increments, but we would need to do it at least in, at the maximum 1-hour increments, not less than that. So if somebody is out, they would get paid for the time they work, but they would have to take it in 1-hour increments. Doing it in quarter-hour increments, we have an attendance policy where I understand you said earlier that you need to keep an eye on employees who are not being honest, but it's very difficult to administer somebody showing up 5 or 10 minutes late and saying they had a cold, they had a headache, child was not feeling well. There's so many reasons that you just can't administratively keep up with that with employees with their reasons. So, 1 hour increments would be the minimum preferable. Our current policy, we do give some leeway on what we call unpaid time off. So they can take in hour increments if they're late for any reason. We don't care. They can take that and not be, applied to the attendance policy. So we try to be cognizant of that, and then we give some paid days off, but it's in full day off, so they get paid if they're sick, their child's sick or whatever, they can take the day off. Actually, we don't really care why they take the day off, because then we don't have to administer.
So you already have a PTO?
For a couple days. Paid time off for 2 days, and then certain time for unpaid time, but it doesn't go against your attendance record, because we try to have an attendance record that we try to apply consistently with all the employees, so we're not subjective as to which employees may have some disciplinary issues and those that don't.
Okay.
So,
thanks for your...
at minimum, I'd love to have I'd love to have the incremented time with that clarification to everybody much earlier so we can implement that.
Okay.
Thank you.
Very
Thank
good.
you.
Thank you.
Going to suspend?
Should we take a 5-minute break or 10-minute break? No, we'll suspend.
Okay. All right. Unless there's anybody else for testimony, we're going to suspend the hearing here, and we're happy to take your questions offline individually. Okay. Thank you.
And this will mark the close of the earned sick time public hearings in Worcester, Massachusetts.